Good afternoon to every one of you to this public hearing with the Trinidad and Tobago Prison Service to raise a couple specific matters that will become clear in a very short while. This public hearing of this Joint Select Committee on National Security is being convened pursuant to this committee's inquiry into the practice whereby prisoners are granted access to services outside of the prison in the main. Might I indicate that this hearing is being broadcast live on the Parliament Channel 11, Parliament Radio 105.5 FM, and Parliament's YouTube channel, ParlView. Might I take the opportunity as well to inform members of the viewing and listening audience that they can send comments via email at PARL or PARL 101 at ttparliament.org or on Facebook page facebook.com/ttparliament or on Twitter at ttparliament. Might I as well take this opportunity to very sincerely welcome the Commissioner of Prisons and other officials of the Trinidad and Tobago Prison Service. And I'll take this opportunity to ask you, Mr. Commissioner, for the record and for the formality, to introduce yourself, and your other colleagues can do similarly. A very good afternoon. Good afternoon, Mr.
Good afternoon again.
Good afternoon.
My name is Sterling Stewart. I'm the Commissioner of Prisons. On my right, we have Mr. Dennis Poolchan, Assistant Commissioner, Acting Assistant Commissioner of Prisons Operation. To my left, we have Mr. Carlos Carraspi, Acting Senior Superintendent of Planning, Transport, and Logistics. And further to my left, we have Mr. Hayden Walcott, Chief Welfare Officer.
Thank you very much, Mr. Commissioner. We're really happy to have you. And you may recall, having received a letter recently, this is no novel experience for you. You've been here before.
Yes,
and
sir.
This committee sent a letter to you some time ago expressing our admiration and appreciation for your prompt responses and forthright responses to the queries that we have raised in one form or the other with you, and we really commend you for that.
Thank you, sir.
Let me take the opportunity to reintroduce myself, Fitzgerald Hines, Chairman of this Joint Select Committee on National Security.
Michael Coppin, Senator, Government.
Will Sturge, Opposition Senator.
Torel Shriki-Soon, Independent Senator.
Nigel Freitas, Government Senator.
Nicole Olivier, Member of Parliament.
We have a member absent, could not be here today, and we are well supported by the very efficient secretariat to this committee, led by, of course, Mrs. Jackie Samson Miguel, the clerk of the House, who sits in a secretary and very strong and supportive staff. The nature of this inquiry is, as I alluded to earlier, largely the policy and the practice by which prisoners are granted access to the free world. I'm speaking in a language that the thousands of citizens listening today would understand, by which prisoners would be allowed access outside of the prison to access services that might be deemed to be necessary. We do so against the background of the fact that when, on the basis of our constitutional arrangements, through the courts, one arm of the state, the judiciary, sends a man or woman, a citizen or visitor, to the prison for remand or to serve time upon conviction, the public has an interest in and is entitled to expect, in pursuance of that public interest, that these persons are kept safely on the inside so as to pose no harm to themselves or others on the inside, including, of course, prison officers and staff of the prison serving there. And certainly the public is entitled to expect as well, on the basis of that public interest, that these people are safely kept therein and do not flow onto the streets in any manner that could bring danger to the public, as in the example of a jailbreak. And having said so, I am now reminded that I would want to reserve some comments on that prison jailbreak situation after we deal with what is in front of us now. So, with that as a backdrop, I would like to allow my colleagues to begin by asking a few basic questions, which upon answer, we will use as a backdrop to advance today's inquiry. Okay, Mr. Commissioner and the team?
Thank you, sir.
Thank you very much. Senator Sturge.
Mr. Commissioner, as a prelude to the question I'm about to ask, there's a difference in status and treatment between remanded prisoners and convicted prisoners. Is that right?
Somewhat. What is happening because of the length of stay that we have remanded inmates, or should we say unconvicted or pretrial inmates within our environment. Take into consideration they are human beings. We have to find ways to help in their development.
Okay, Mr. Commissioner, hold on. I think the short answer was yes. So, sorry to cut you and not meaning to be rude. As I said, it was a prelude to a question relevant, pertinent to what we're about to embark upon. Since there's a difference in status and treatment, as you agree, between remanded persons and convicted prisoners, we wish to ask questions more particularly about remanded prisoners. Whether there is a policy or a standing operating procedure in existence for taking remanded prisoners out of the prison to conduct business. Is there a policy or standard operating procedure in writing that you can point us to?
I could point you to the, coming out from the 2002 task force report on prison reform and transformation. Certain aspect of that report was approved by the cabinet.
Mr. Commissioner, hold on. Is the answer yes or no? Is there something in writing you can point us to? Law, for instance, or prison rules?
The reintegration penal policy.
The reintegration penal policy?
Yes, sir.
Does that, is that relevant to remand prisoners? Or is that not more pertinent to convicted prisoners?
It is relevant and pertinent to both convicted and convicted. It is relevant and pertinent to incarcerated inmates.
Right. So what I'm asking, and you haven't answered yes, the Prisons Act or the Prison Service Act, can you point us to provisions dealing with taking remanded prisoners out of prison to conduct business?
Are you speaking specifically about the archaic 1813?
I'm speaking about the legislation that is in force. I want to ask whether there is in either the Prison Service Act or the Prisons Act legislative support that facilitates such transactions. Yes or no?
No.
No. And in the prison rules, the rules that are in existence, can you point us to where in these rules there's some policy or procedure outlined with respect to taking remanded prisoners out of prison to conduct transactions?
Well, let me put it this way.
Without putting it this way, is there a place in the prison rules, and you must be familiar with the prison rules, that you can point us to, perhaps Rule 1, Rule 2, Rule 10, Rule 20? Is there a place you can point us to?
I want to point it to the policy that we operate under now in this year time.
Is it a written policy?
As I told you about the reintegration penal policy, it was operated because it was adopted by the cabinet.
But it's not law. So, okay, let's
operate on in this year time. That will treat with the environment.
So hold on 1 minute. We are dealing with law enacted by the Parliament and rules provided for by these laws. So what I want to get from you, since you cannot point me to anything in the Prison Act or the Prison Service Act, and you are yet to point me to anything in the prison service rules which has been given support by the parent legislation, is there anything legislatively to allow for such transactions? Is there anything, listen to the question again, is there anything legislatively that would give you such power?
The penal policy.
Sir, the penal policy is not legislation.
Well,
you agree?
Then in that aspect, no.
Right, so there's no power in legislation that allows for that. You agree? Having regard to what you just said. Do you agree or do you not agree?
I agree to...
You agree. Now, Mr. Commissioner, I want to ask, a prison officer who was charged with murder in 2009 and who is still remanded in custody, is not yet been tried, was taken outside the walls of the prisons to conduct a banking transaction. You are familiar with that issue, correct?
I am.
You are aware that this issue was raised and put into the public domain by a police officer who carries on a television show. I believe it's Beyond the Tape. You are aware it was put into the public domain by one Inspector Alexander. You are aware of that?
I am.
And you are aware that Mr. Saren Richards, who heads the Prison Officers Association, made some certain remarks, denigrating remarks about what Mr. Alexander, Inspector Alexander, had said on his program. You are aware of that?
No, I'm not aware of the president of the association making any denigrating remarks.
Okay, let me leave the word denigrating out of it.
Thank you.
Making remarks.
Let me, for the benefit of the public who are part of this exercise, share with the Commissioner, since he's not aware,
Yes.
that it was reported in all of the daily newspapers, but I have before me page 10 of the Newsday section A of Monday, November the 28th, 2016, under the rubric or headline, Saren Richards slams Inspector Alexander. The headline says, "He is too disrespectful!" Exclamation mark. And the story says in part, the prison service in a news release, and that's the prison service it claims, Mr. Commissioner. Before I go further, did the prison service issue a release in this matter, or was it just the association speaking?
We did issue a release in this
The prison
matter.
service issued a release.
So,
All right, might I continue then? Yes. So both the prison service, under the authority of the lofty office of commissioner, and the association commented or reacted to the story as published by Mr. Alexander and Beyond the Tape.
you're correct, sir.
The prisons, and I'm quoting, the prison service in a news release also condemned the report, calling it reckless, irresponsible, ill-informed, and malicious. He is too disrespectful and callous, Richards said yesterday. Well, in typical newspaper style, they juxtapose the prison services statement with Alexander's comments. You know how the newspapers in this country would do it in titillating style. But that particular statement apparently fell from the lips of Mr. Alexander, that he is too Mr. Richards, that he is too disrespectful and callous. His actions on Friday misled members of the public into thinking that the hard-working members of the prison service are conducting illegal activities, and so the story goes on. And generally, Mr. Richards was condemnatory of Mr. Alexander's public comments on the matter. That is what Mr. Sturge is asking if you were aware of. Are you aware of that?
I am aware of it.
Great.
Lovely.
Please continue, Mr.
Thank you,
Sturge.
Mr. Chairman. So you are aware of the comments of Mr. Richards, head of the Prison Officers Association. Did you condemn or disassociate yourself or the prison service from the comments of Mr. Richards?
I said in my capacity as the commissioner, what I thought about the comments on TV of Inspector Alexander and Marlon Hutchinson or whatever.
Right.
So I said what I, in the capacity of commissioner, I made a statement.
The essence of your statement was what?
The essence of my statement was focus on your police business.
Right, but sir, a remanded prisoner is police business, is that not right?
He now care his prison business. Why
So, whilst he is in the prison, he is being kept by you because there's no remand center per se, is that correct?
Repeat the question.
So, whilst he is being kept at the prison, pre-trial, remanded, not yet convicted, he is the property of the court. That's the first thing, correct?
He's kept by warrant within our environment and he's the property of the court.
Right, so
Until that
for
is
him...
delivered to the court.
Right, so if he is property of the court, loosely, he's taken out of prison by warrant and brought back to prison with a warrant. Is that right? A remanded prisoner is taken out of prison by warrant and brought back into the prison by warrant, correct?
Not in all cases.
Remanded
if you have to go
prisoners.
to court, he's brought out of the prison by warrant and then over to the police,
Lovely.
transported to the court, and returned to the court.
Right, so the short point
in
is...
that aspect of it.
Right, so the short point is he's not transported by you, he's transported by the police, correct?
On his way to the court, in that aspect of it.
Right, and he's in your care when he's brought back in.
He is under the jurisdiction of the prison service and the commissioner of prison by extension.
So he's kept by the prison, but he's really under the jurisdiction of the court. Is that not right? You are keeping him for the court. Is that correct?
Keeping him for the court.
Right.
That is
He's
correct.
not a convicted prisoner who you keep in your capacity as commissioner of prisons, correct? Yes?
As
So, a convicted prisoner, already convicted by the court, lost his appeals, you are there to hold him and treat him and rehabilitate him until release, correct? There's no court...
in my care,
So is that correct, yes or no?
do you want me to
I want you, listen, you'll have a chance,
answer?
you'll have a chance to explain, but we want to get certain things out of the way and then we'll allow you to explain. So if you can help us not go the scenic route and stay on point, you would agree, first of all, that he's different to a remanded prisoner is different to a convicted prisoner, in that when the prisoner, the remanded person is taken out of prison, it's usually by warrant of the court, taken out and brought back.
On a remanded prisoner is sometimes taken to clinic without a warrant.
So you can take...
By prison officers.
Right. Lovely.
So that is an example of one of the ways that the remanded inmate is taken out of prison without a warrant and not taken to court.
And that's by necessity, correct? It's necessity.
You asked a question.
Well, sir, you can't wait for it's a situation where he may lose his life, he needs urgent medical treatment, which you cannot provide, so you take him to the hospital because if you wait on the court, he might die.
In different instances that he has clinic dates that we seek to assist him to. So it mightn't be of necessity, but you have the clinic dates. If you want to use the word necessity, I understand.
Right. Let me ask you about...
In addition to that, he also is taken out, for example, for viewing of corpse. Maybe a family member, whatever, he's allowed to be taken to view corpse.
Right. I am glad you brought that up.
I know.
There's a chap by the name of Jerome Henry whose child drowned, 4-year-old child drowned whilst he was out looking for work. But you all didn't take him to the funeral, did you?
You're talking to me specifically at the Commissioner of Prisons?
I'm talking about the prisons.
Wait.
Before you do
Go
answer,
ahead, sir.
let me declare at this point, since my colleague and committee member, Mr. Senator Sturge, raised the matter, let me declare publicly that I have some personal knowledge and involvement in the issue raised as it relates to Jerome Henry, in the sense that as Member of Parliament, he's one of my constituents. I was part of the hundreds of people who gathered around his family on that very fateful day when that child was lost to torrential rains and a swollen river in the neighborhood. And as a result, I have personal knowledge and dealing with it. I want to further declare that I visited Jerome Henry at the Belmont police station after his arrest and during the time of the police inquiry. And I want to further declare that I attended the funeral service of that innocent soul, Josiah, may his little soul rest in peace, and shared the commiserations and the sadness with all of Trinidad and Tobago on the day of his internment. So as a result, I have had some personal contact and dealing with this. I want to declare that. So with that said, I want to say, based on my knowledge, Mr. Sterling Stewart, the substantive Commissioner of Prisons, was not in office at that time and in those circumstances. He was on vacation leave. Am I correct, Commissioner? And out of the jurisdiction, because the record is I made an attempt to get to Mr. Stewart to resolve what I considered to be a serious matter. And it transpired that there was an acting Commissioner of Police. Would you like to remind us who was?
Commissioner of Prisons, sir.
Prison, sorry, I'm terribly sorry. Yeah.
Who was that?
Sorry, sir. Sorry.
Yes,
for
not at
putting
all.
you down.
Yes.
The acting Commissioner of Prison, Mr. Cecil Duke, sir.
Yes.
He was performing the duty of Commissioner of Prison at that. Mr. Cecil Duke, sir. Yes. Mr. Cecil Duke.
Yes.
He was the acting Commissioner of Prison performing the duties of Commissioner of Prison because I was on vacation.
All right, great. And I would like to finally declare that I spoke on the day of that funeral to Acting Commissioner Cecil Duke, and, well, I'll have more to say about that later. So may you continue. So
Yes.
Mr. Stewart was not actually in the chair on that day. It was Acting Commissioner Cecil Duke. So when Mr. Stewart asks if it's him personally, you know, so
yes,
you can
well,
answer on behalf of the prison service,
I
of
understand.
course.
I understand. But Mr. Stewart, since this was raised in the public domain and you understand there was a huge outcry about him, Mr. Jerome Henry not being allowed to go to the funeral of his son, did you inquire upon your return as to why Mr. Henry was not allowed to see his son, go to attend the funeral?
I did.
And what was the explanation?
Well, at the time, it was a discretionary decision of the person who was acting in the capacity of commissioner at that time that he made a decision.
So it's a discretion that Mr. Duke exercised?
Yes, Mr. Sturge.
Yes. Now, having got the exercise of that discretion, you would agree from your own inquiries that Mr. Jerome Henry was charged with willful neglect of a child?
I'm aware of that, sir.
In essence, the charge was that he left his child at home, went out to work, and the child perished whilst he was away. So this is, in essence, a crime by omission, correct?
You are correct.
So that Mr. Henry is not a violent offender, correct?
I'm not in a position to say that. What I can say, though,
He's
is
not
that,
charged with...
that before we... Can I...
Yes, you
allow
can.
me to answer?
Sorry?
Would you allow me to answer, sir?
Of course you can answer.
Thank you very much. Before any inmate is allowed to leave the environment of the prison service, a risk assessment is conducted on them. and a decision will be made based on the report coming out of the risk assessment.
Oh, can you, from your inquiries made of Mr. Duke, tell us if Mr. Jerome Henry was deemed a violent person?
That discussion didn't lead down that way. We did not
Correct,
go
because
in that direction.
from his...
But I don't believe... Sir? We did not discuss that aspect of it. On my return, we discussed Mr. Henry not being allowed to go to the funeral of his son.
Did you ask why?
There's procedures in place. I already told you that it was a discretionary decision
I know it's a discussion.
made by the person in the capacity of commissioner at that time.
I know, I'm simply asking you, did you ask the acting commissioner at the time, simply he exercises discretion and we accept that. Did you ask him why he exercises discretion in that way?
I can't recall. I don't think that I got any, was asked or that came up or I received an answer concerning why he didn't allow the request for the gentleman to leave the confines of the prison service to attend his son's funeral. We didn't discuss that part
Right.
of it.
But, so now, well, he's not charged with murder, and you understand murder, like stabbing one's wife to death. A person charged with stabbing his wife to death would be categorized as a violent offender.
I don't know. I understand alleged.
Alleged, right.
Yeah, and
But
I
if he's
understand that
alleged,
from that aspect, yeah.
right. So the state is saying someone who stabbed his wife to death is a violent offender, right? Mr. Henry, Jerome Henry, who by omission his child died whilst he was not present, is not a violent offender. But we have here a man who's charged, a prison officer charged with murdering his wife, is taken to a bank to conduct a transaction. That's discretionary also?
So let me say it this way to you.
I'm asking you, was that also discretionary, since you earlier said there were no legal provisions for doing so?
Based on the assessment and the procedure that was taken, yes, sir. And within the policy of, I said, of the reintegration penal policy which we operate under at this time.
Sir, there's a distinction, hold on, between Jerome Henry, who is remanded, and he's not a violent offender, and someone who is remanded for murder, being taken not to a funeral, but to conduct banking transactions. There's a distinction, correct?
It is, but...
Right. So, sir, I want to know right now, are prison officers given preferential treatment compared to persons like Mr. Jerome Henry, who your organization did not allow to see his son to take part in the final funerary rites?
When you say prison officers, when you come into our system on a warrant, you are a prisoner straight across the board. Consequently, you will be coming before us with a warrant. I don't know about a prisoner. It have prison officer, prisoner. It have either a prisoner, inmate of the institution, or your officer, like the gentleman with me here now.
right.
Yes,
But
what I want to get at, Mr. Stewart.
So it have nothing but bias and prejudice or any discrimination. That's what you want to get at.
Okay,
I'm telling you,
Mr.
no,
Sturge.
it's not at all.
Yes, I understand you to be saying, Mr. Commissioner, that in your professional judgment, once an individual enters your precincts upon warrant of the court or an order of the court, he is not teacher, prison officer, or priest. He is simply an incarcerated person. Is that the position you're taking?
That is exactly
All right,
the
thank you.
position I'm
Let
taking,
me,
sir.
before you think, let me invite our colleague, Ms. Oliver, who's trying to gain my attention. Thank you.
Thank you very much. Mr. Stewart,
Could I say one thing, sir?
No, just take the question.
All right, sure,
You'll have a
sure.
chance, yes.
Yes, Mr. Stewart. Now, the incident that Inspector Alexander brought in the public domain, it certainly caused a lot of questions in the minds of the general public. So the first question I'd like to inquire from you is, are there some guidelines that you use, is it under the reintegration penal policy, where there are guidelines that you use in determining whether or not a prisoner can be allowed to come out of the prison to conduct a particular transaction? Are these guidelines written?
There are policies concerning that. What is happening is that my job as a commissioner, our mission statement, it's the preparation or reintegration of all the personnel that comes into our care, preparing them for coming out one day as we believe that we come back to the neighborhood and the community. As such, based on the request, there is a system and a policy where based on the request of the inmate, there is a procedure to follow where at the end of the day, the commissioner will make a decision. If the inmate is no longer, is not a risk to the society or the citizenry of Trinidad and Tobago, and we put the necessary security measures in place, protocols that we will allow the person to go outside, because lives continue. And we are saying that in light of our new trust, the restorative philosophy, and like that, we have inmates, both convicted and unconvicted, and in the case that we are speaking about the unconvicted, for a number of years within our environment, we have to see how possible it is to help keep that connection and the development.
We accept that. Go ahead, member.
I have further questions. Okay, thank you very much for that. Now, since this is a policy that you have, could you give an indication of how frequently this policy is applied? I ask this because in this particular instance, it is only because coincidentally there was someone at the facility at the time who recognized the individual that this became known to the public. So how frequently are inmates brought out to conduct transactions that the general public isn't aware of?
I will answer this in this way. Besides transaction, a number of inmates are allowed to go out into the public domain. We programmed a number of programs that they have been allowed, both convicted and unconvicted, on a continuous basis based on the request. We have inmates going outside, they are both convicted and convicted, mentoring in the schools and the communities, because we believe that prevention is better than care. And we see, through our programs, trust and their development and growth, we see that we could utilize these certain persons to repay and to assist in this whole crime challenges that we have now within our mission statement.
But Mr. Commissioner, one sec. But Mr. Commissioner, you did not answer the question of the member. The question was, do you have records as to how frequently inmates have been allowed outside?
Yes, sir.
Do you have those records to answer that question to the member today, now?
Yes, sir.
Well,
Could you
over
please?
the past year or so, how frequently has it happened in this year so far? So this, just to give an indication of it. Now, before you answer that, now, I am aware of certain structured programs where inmates are brought into the community. As I recall, it might have been 2 Saturdays ago, some of the female inmates were taken to the Point Fortin, Victor Trinket Park, and they would have engaged with the community. So I'm not speaking about those structured programs where it would have been a certain number of inmates, and there would have been a large contingent. So they were clearly identified as prisoners, and the public was informed of the situation. But I'm really speaking about these individual situations where a particular prisoner or inmate, incarcerated person, is brought out to conduct a personal type business. So
yeah,
how frequently does that occur? So
we have our welfare officer here that will be in the best position, because he's the only person who will have to do the initial investigation and bring it to the attention for approval to the commissioner. So he do the welfare department, do the groundwork for any movements of inmates internally or externally. So he will be in a position to answer that, for you to get a better picture of what you
Well, I'm sure the number of persons listening right now who possibly have relatives who are inmates would be very interested in hearing your response, so they can get information onto how they too can apply for similar services.
Before he does, though, let me make an intervention. As you said, Commissioner, prisoners are moved outside of the walls of the prisons for various reasons. Today, we are not talking about activity that is designed for mentoring as part of the rehabilitation process. We are not talking about that. Today, we are talking about a specific situation where an individual in your custody wanted to have his personal business transacted outside, and he was allowed. That is the category that the member was asking us to confine ourselves to. We have no doubts, because I've seen prisoners cut trees outside. They've done work to assist people. There are any number of reasons why prisoners come out. I've seen youngsters come out to speak to students as part of mentoring and all that. That's not what we're dealing with today. What we're dealing with today is where you have a situation where an inmate has a personal matter that he wants resolved outside of the prison. Are you with me? So I want us to confine ourselves to that today. So I would like the answer to the question, how many times is it a frequent occurrence? Do you have statistics to demonstrate how often are prisoners who want a driver's license, an ID card, a bank transaction, you know, to go and visit an ailing relative or to go to, to a funeral service? That's the category we're talking about, not part of your rehabilitation program. Thank you.
Yes, thank you again, H. Walker, Chief Prison Welfare Officer. Since January 1st, 2015 to now, as of now, we have had 9 persons who went to the bank to do a transaction. Right? Most of them were in fact at the youth training center in terms, and that was done in terms of the reintegration, because many of them have OJTs and it is required that they have a bank account, and especially the amount of monies that they have. Right? In this particular instance in which the public is so thinking about, I need to go back, of course, to create a picture of what actually occurred. Now, this inmate, I beg of leave not to call his name, because of course...
We're comfortable with that.
Thank you.
Thank you.
Right? He came into to our care in January 2010. Right? Within 8 or 12 days of that, he had a power of attorney done for a family member in terms of his banking transactions and in terms of his other financial matters. Right? He also had a bank card, which he handed over to his family members to continue that transactions. Right? Right? And this money was used to pay his, according to him, his legal fees and other issues, because unlike other inmates, other remanded inmates, he will be one of the few who will be continue to be getting paid. Because most of our clients, once they come into the prison, their jobs are terminated. They may not have a steady income coming in while they are incarcerated. He is one of the few that actually occurred. So because of that, of course, monies will be going to his account every month, right? And the way that the family dealt with it, it was, of course, the bank card. So his personal bank card, his family had that, and they went and they withdrew it. A problem came about, however, in 2015. So we were in 2010, 2015, when something went wrong with the bank card. The bank card was inoperable. They went to the bank, and the bank said, well, of course, this is not your bank card, of course, so we cannot deal with you. This is, of course, somebody else's bank card. Now, we must also understand that the money was not only used for legal purposes, it was also used for his family to buy toiletries and other things, as well as to finance his child. Right? So it was a three-pronged use of the funds. Right? The family came to us with this issue, right? We contacted the inmate and asked the inmate what he wanted to do. Of course, he wanted his family, of course, to continue using the card. We contacted the bank. The bank said, under no condition can a third party, of course, come to collect a new card because the account is in one person's name, of course, which is him, and he's in custody. We inquired from the bank if they would be willing to come to the prison to facilitate that because that money is critical for him in terms of his legal matters and expenses. They said no. The power of attorney, which he had since 2010, they tried to also to use that, and the bank said they was unwilling to use that power of attorney. So since from 2010, he is in custody. 2015, everything went smooth in terms of that. Right, so money was building up in his account. He needed the money to pay his legal fees, and that was his only way of paying his legal fees.
So, based on what you have said, the prison service felt that it was quite reasonable to take this inmate to the bank to resolve the issue of the bank card.
But before we even got to that, the welfare department, of course, did an investigation. We contacted the bank, of course, and we asked the bank what is the options given that he is incarcerated. And they said the only option was, because they agree as well that something may happen again with the card, it may lose, and all of these issues in terms of the bank card. And the bank recommended, they said the best option was for him to have a joint account with someone, which gives that person that power, so that in case the bank card loses, in case there's an issue with the bank card, anytime, there will be no problems in terms of that person who is outside to get the card.
And you all agreed that it would be a good idea for him to go to transact that important affair?
Yes, because and when we observe all the other risks, at the time, we felt that was the only other solution. Now,
what other risks did you contemplate? To use your words, other risks. What other risks did you contemplate?
One of the critical risks, of course, is that harm to the external environment, namely the bank, namely employees of the bank, namely workers, namely users of the bank. We had discussions with the bank in terms of how to operate. They give us their guidelines. They had their talk to their people. And a measure was observed in terms of how this could be done as safely as possible and as quickly as possible.
Any other risks you contemplated?
In terms of it, no, because his prior behavior, in terms of any behavior that he demonstrated while in custody, he demonstrated no outward violence or outward risk.
You did not contemplate harm being done to him?
Yes, sir, and in terms of that, so that is why ample security was put in place prior to that.
You said ample, but the public, the two members of the public, the relatives of, the parents of, the deceased in the matter for which he stands alleged to have committed, it transpired that they were at the bank.
Yes.
You didn't contemplate that possibility?
No, sir.
Good. You did not contemplate the effect that his presence in the bank would have had on the witnesses in the matter that he is before the court for? You didn't consider that?
We did not consider that because the possibility, because when we operated with a bank, we tried to operate with confidentiality, and we operated so that it will happen, the whole interaction will go as quickly and as smoothly as possible.
But during regular banking hours?
Right, as prescribed by the bank.
Yes.
We cannot tell the bank how to operate.
No, but the bank can't tell you how to operate too in accordance with your prison mandate.
Yes.
You accept that?
So, yes.
Hold on. So you did not contemplate the possibility of him interfacing with relatives of the deceased in the matter?
Well,
You
in
didn't think of that?
terms of the security protocols, he cannot interface with members of
Talking
the
about
public.
security, what's your name, sir, Mr. Walcott?
Yes, sir.
Talking about security, from the public record in this matter, from the report of the family members, there was no security in the sense that they did not see uniformed personnel. They didn't see soldier, they didn't see prison officer, nor did they see police. Did you all have any uniformed personnel there with the man on that day?
So that was a deliberate thing not to have...
Question is,
No, sir.
did you all have uniformed personnel there?
No, sir.
Was the police present?
The police was informed, sir.
Was the police present?
No, sir.
Was members of the Trinidad and Tobago Defense Force who assist in managing affairs in the society, were any members present?
No, sir.
So as far as you are aware, there were no uniformed personnel there.
No, sir.
So you can now imagine someone seeing him, and knowing of the reason why he was incarcerated, must be astounded to see him on his own transacting a financial account in a bank. You will accept that?
Sir, I cannot say what a person...
Just a
or will not
second,
feel,
just a
sir.
second. Was he handcuffed?
He was handcuffed on his way to the bank, and when he reached the bank, to ensure that we operate in a stealth-like manner, which means we did not want that the public be eyes on the public, and the public knows what is going on in terms of disrupting the bank's normal
So when
daily
he
operations.
entered the bank, he was not handcuffed.
Once he entered the bank, he was handcuffed. He was not handcuffed on entering the bank.
Good. So here was this man transacting a business affair in the bank, apparently without any security around from the eyes of an observer.
Well, for us, sir, we had security
Through
in
the
place.
eyes of an observer who wasn't part of the prison arrangement that day, it would appear obviously that there was no security. You accept that? That's common sense.
I don't accept that, sir.
You don't accept that. Okay, that's a matter for the public to judge. And no handcuffs.
He had handcuffs, sir.
No handcuffs, you just told me
On
inside of the
entering,
bank.
no, sir.
No, sir, he was not handcuffed
Okay.
while entering the bank.
Okay.
Welcome, Emily.
Did you, finally, my final question before I take Senator De Freitas, in the contemplation of the risks, did you contemplate at all the effect that his presence in the circumstances we have just described can have had on witnesses in that matter, or potential witnesses in that matter, or witnesses in the criminal justice system generally? Did you all take account of that possibility or those?
So that is a hypothetical issue.
No, it's
In
not
terms-
hypothetical.
In terms of in terms of that, it is difficult for us.
Mr. Walcott,
to
just
actually-
hold on, please. Permit me.
Sure, sir.
You introduced the word hypothetical. I think I understand what that means.
Yes, sir.
I'm suggesting to you it is not a hypothetical situation. Let me put the question again. Did you contemplate or take into account the impact of his presence without uniformed personnel, without handcuff, against the background of the allegations that he is facing, against the fact that he was supposed to be inside of the walls, appeared in the bank? Did you, in your contemplation or consideration of the risks, did you consider the impact that his presence in those circumstances could have had on witnesses in his matter, potential witnesses in his matter, and witnesses in the criminal justice system generally who would be affronted by this situation? Did you consider that?
We did, sir, but that is one of the reasons we operated in a stealth-like manner and to operate in as quickly as possible.
Finally, you did, and you still acted in that way. Finally, before I give way to Mr. De Freitas, did you consider that it was possible that he can have gone to the bank after the public banking hours, because the bank stops its public operations at about 2 p.m., from my common sense knowledge. Can he not have gone between 2 and 4 p.m.? Did you consider that at all?
Sir, we had to liaise with the external agency, and the external agency is the bank. So we
I asked
yes,
you a
sir.
specific question.
Yes, sir.
Did you consider
Yes, sir.
and raise the possibility of him going between, say, 2 and 4
Yes, sir.
p.m.? You did? You did that?
Our
You
investigations.
raised that with the bank?
No, I do not have, because I did not investigate that matter. That matter was investigated by a junior officer, right? So in terms of exactly what you are saying, in terms of whether that was discussed, in terms of it, normally we do. I do not have it documented.
All right.
In terms
Senator
of that
De
discussion
Freitas.
happened.
Thank you.
Thank you,
Thank you,
Mr. Chairman. I am sitting here listening, and let me just say I'm not a lawyer or criminal lawyer or anything, but I'm picking up certain things as I listen. And I would ask for the assistance of Senator Sturge or any other criminal lawyers that is part of the panel as I make certain statements. But some of the things that I'm hearing is, one, you're speaking to rehabilitation. And for me, when I hear the word rehabilitation, I am thinking of someone who has gone through the court process and has been convicted. And therefore, you need to rehabilitate that person after it has been proven by a jury of your peers that you've broken the law. The two instances that we are speaking about now speaks to individuals who, by judicial process, are innocent until proven guilty. So there is no need for rehabilitation of individuals who are on remand. Let me tell you why. Because if they go through the court process and then are proven guilty by, innocent by a jury of their peers, then why would you have been rehabilitating them in the first place? That's one. Second, under remand, there is a process, as far as I understand, that if people under remand need to continue their lives, they can access bail either by paying, or if the offense that they have committed is a non-bailable offense, which says basically that this person is risky to give them bail and dangerous, right? I want to assume that the individual who is on remand for a violent offense did not or cannot, under our laws in this country, access bail, which in a nutshell, or in layman's terms, basically means you do not leave the prison, period. Unless under extenuating circumstances, which you have indicated equal to critical to the life of the individual, where they need to go to a clinic, or in less extenuating circumstances than that, they need to view a body. Doing a bank transaction under the laws of this country is not extenuating circumstances. You have said here today in front of this panel that you as prison officers deemed it necessary for this individual to fix a problem with a bank card, and therefore took it upon yourselves, absent policy, in against whatever procedures are put in place here in regards to bail or non-bailable offenses and whatnot, to take this individual to fix a bank problem. So I ask the question, God forbid that this violent offender under remand had escaped and is in the public domain, absence police involvement, because his prisons has taken him to the bank, who would be accountable and responsible for that? What investigation could have taken place absent a policy that dictates, one, how, why, and when he can go there? Secondary to that, if you are dealing with the bank and you have spoken to the bank and you have notified the bank that this is an individual on remand, why was there need for stealth? I have seen instances where prisoners have been transported from Trinidad to Tobago for court, handcuffed on the boat, and everybody on that boat in the public domain knows that this is a prisoner being transported. Why is there need for stealth in the bank? If you are dealing with the bank, was the manager on hand to deal with the transaction? Was it a subordinate? If something had happened to that subordinate individual in the bank who is at risk, the manager could have lost their job. You must give the bank, based on their procedure, the ability to deal with that transaction based on what the uniqueness of that transaction. As far as I can see, that was not done. I don't even know if the manager was the one signing off on that. As a matter of fact, I've also seen in the bank for less unique circumstances where the bank manager will leave the bank, come into the parking lot, and allow whoever it is to sign off on whatever documents to get certain things done, which would have been more secure in this circumstance. So as far as I'm seeing here, in the absence of policy, people were at risk. The witnesses that were in the bank, the public, the prisoner, they were at risk. And what I'm hearing is that the prison service took it upon themselves to determine that this was such an important transaction that they would put all these people at risk. My final question is this: what risk assessment would allow a violent offender to fall lower on the risk assessment than someone who did not premeditated kill their son and cannot go to the funeral? What risk assessment would put someone who is a violent offender and on remand lower on that risk assessment than someone who just by accident, really, lost a son and cannot go to the funeral? Can you answer that question for me and the people of Trinidad and Tobago?
Thank you, Mr. De Freitas. I would perhaps treat with the second question first, the issue of the fact that the inmate was remanded and not convicted. You know, one High Court judge said that dubious interval between when a matter is completely adjudicated. What do we do with the inmate? In a perfect world, the prison will only treat with convicted inmates because the matter would finish in one day. But we're not in a perfect world. The fact is, as insofar as the habilitation aspect of the rehabilitation, our Constitution provides that the person loses the right by due process. That right to life, liberty can be lost by due process. In the circumstances where someone is brought to, a remanded inmate is brought to prison, the general principle is that the person ought not to lose the fullness of these rights. You try to limit the rights that could be lost by that individual. And therefore, while we recognize that the liberty is lost, the prison yet has a responsibility, given the principle of innocent until proven guilty, that to try to reduce the fallout in terms of these rights, where the remanded inmates are concerned. In this particular case, this is someone who was in prison for 5 years, who, as the colleague would have indicated, they would have required the monies to meet their legal costs. There is a deprivation that goes with taking away the capacity to pay legal bills. And therefore, the question really was, what could be done in these circumstances to reduce that possible negative fallout? Again, the prisoner makes the request. So it is perhaps should not be considered that the prison initiates the process. The prisoner makes the request through the superintendent, and of course the risk assessment is done. And we try to do what is best in every circumstance, and it's not all the time we're going to get it right. Perhaps some things may be within contemplation, and oftentimes when situations happen, we take that on board going forward.
Made a very, very forceful point. Senator is saying, the member is saying, when you have someone who is charged for a non-bailable offense in accordance with the law, it means that one arm of the state has taken, based on the law, has taken the position that this situation is so serious, he ought not to be allowed outside of outside of the walls of incarceration. And as you design your policy for allowing persons when you deem it necessary outside, the senator is implying that you need to take into account very seriously those who are not allowed bail in its entirety by the court. That's a tall argument, an irresistible argument in my own view, except if life is at risk, the man falls ill or something. So I find the senator's position very persuasive. So as you review this policy, and I hope that you will, because there are a whole lot of other things to contemplate. That is one of the things you must contemplate in exercising this discretion You with me, Mr. Commissioner?
Sir, we always contemplate, as our mission statement states, the risk to the citizen of Trinidad and Tobago.
No, we are not talking about the risk.
And what are we saying?
We're
sir?
not talking about the risk.
In the idea,
We're talking about the fact that the courts of Trinidad and Tobago, as an arm of the state, on the basis of the Constitution and the law, say for this particular offense, it is non-bailable. That's what we're talking about now.
But let me
so
just
I understand. So it have persons and non-available offenses in our environment for 10 to 15 years. As human beings, should we have them locked away and not allow them, if we do our inquiries into, we do our assessment, and we deem that they're no longer a risk to society, should we not give them an opportunity in the whole rehabilitation,
Just a second, please, Senator.
to come out? Because we have been doing that as part of the preparation for reintegration.
So
all people, as I said, stated from before,
Let me
understand.
ask that. So this is this the two questions I want to ask? This is not the only case where a man accused of murder, a man who is incarcerated and remanded on a murder charge. This is not the only case where a man would have been allowed to conduct his private transactions other than in circumstances of life and death.
No, sir.
You've had other cases
Yes, sir.
where persons who are incarcerated on allegations of murder have been allowed out on the basis of this discretion other than for emergency medical care or to go and see a relative who would have passed or something?
Yes, sir.
You've had that?
Yes, sir, on a number of occasions, sir.
No,
Because
Mr. Chairman,
so you see, I would ask if prison is to be used for punishment as punishment. We have to find a way to keep with what we're dealing with, sir. The life thing is about, we have a number of individuals in our environment on remand, unconvicted, we focus on that.
That I submit is important.
That is a challenge to us.
Just a second, Mr. Commissioner. That is very important. It's a challenge to the society, but it is not immediately relevant to what we are dealing with today. Senator Coppin.
Question to Mr. Walcott in particular. I am not entirely convinced as an attorney myself that, I'm not saying that you're lying by any means, but I'm not totally convinced that the power of attorney was not sufficient in these circumstances. I've done numerous powers of attorneys. I'm sure Senator Sturgeon, Mr. Hines would attest to the powers of attorneys in allowing persons to act on behalf of other individuals in circumstances like these. You, in particular, said that between January 1st, 2015, up until the material time, which was November, that 9 persons would have been allowed to go out into the world to conduct banking transactions. Of those, you said, 9 of those 9, a number of them, you didn't identify how many were remandees of YTC. What I would like to clarify, because the devil really is in the detail, right? Whether or not there was some level of favoritism, as appears to be, the public seems to have alleged, is in fact true, or to be borne out in the statistics. So I really want to come from a really objective perspective. I want to know, of that 9, how many were adult remandees, that is, remanded into custody in the prisons, not YTC. I also want to know, of those adult remandees in prison, what are the types of offenses those persons were incarcerated for? And further, to allay my own fears or doubts, in the last 5 years, I don't know if you have those statistics, which might, or perhaps you can provide the committee with that at a later stage. But you may have, I'm sure, the statistics between January the 1st, 2015 and to present. Of those 9, how many were adult, and what were the offenses which they were in prison or incarcerated for.
Yeah. Thank you again. Now, first thing we need to understand, now this is taken in terms of our context, right? Because I need to explain this.
Well, it's a very simple question, to be honest. It really needs no explanation. Right. It's the numbers.
The numbers are, the numbers are the Youth Training Center of it.
You just said not youth prison center.
And you wanted for remand?
Adults on remand.
Remand, one person made that application.
So that's a prison officer?
Yes, one person made that application
Jesus
process.
Christ. And you are telling me there was no favoritism?
How much more? We have one, excuse me, we have one next.
No, I want to ask a few questions before we lose. I want to ask a few questions. I heard that a few minutes ago you said the TTPS was informed. Who in the TTPS did you inform?
We always contact the police station. The nearest police station.
Okay.
Responsibility of the superintendent of
Can you tell us?
Station to call the police station and inform them of our whereabouts.
Sir, you took a prisoner to conduct, who is a prison officer and charged with murder, an offense of violence, to conduct a banking transaction. The way I understand it from court, you would have a note in one of your diaries that you informed X person. So what I want to know is, who did you inform in the police service that you were taking this prisoner to the bank? Give me a name.
So,
no.
Yeah, unfortunately, we don't have that documentation with me, but the process is.
Sir.
No, sir, I do not have the name of the person.
Sir, you knew you were coming here to deal with this issue, right? And you knew full well that you had to provide information on this issue. From what I am seeing, before I go to my next question, from the releases coming out of the prison, both you and Prison Officers Association, that this operation was conducted in conjunction by Prisons Welfare Department in conjunction with the bank security. From your own releases, I'm seeing no mention of the police. That's the first thing. So I want to know who. I need a name. Even if not today, we need a name because I have my doubts. I'll be very frank. The second thing is...
Now, let me, from the standpoint of the chair, let me say we would like to receive that information
and the correspondence
in writing.
Yes, a copy of the extract. Secondly, I have an issue with respect to the power of attorney because, like my colleague Mr. Coppin, as I understand it, powers of attorneys can be limited, and in most cases, and in a case like this, I expect he would have a lawyer, so his power of attorney would not have expired. So I want to know, since the bank is saying that the power of attorney could not work, do you have any documentation where you wrote the bank and the bank wrote back to you saying it would not work or it would not work for this reason? Do you have anything in writing?
Sir?
Yeah, that's yes or no?
The issue related to this was that a family member went to the bank.
So
we contacted the bank as well, verbally, verbally when the officer did his initial investigation, right? And we were informed due to the nature of it that they were unprepared to take the document.
Okay,
so you had that power of attorney available to this committee?
Yes, sir.
Right.
You can do so?
Yes,
because
sir,
I'm sure the prison would have kept a copy of that.
Yes, sir. We can.
Okay, we look forward to that as well.
Yes, yeah, you have it.
Senator, colleague, Madam Oliveri.
I am very concerned about the application of this procedure going forward. Yes, an incident took place, and we are trying to elucidate the facts, the material facts concerning that. However, from the way you've spoken, I mean, it seems as though some aspects of this was treated as routinely. Like, for example, you said a junior officer would have investigated.
Prison welfare officer.
But a junior prison welfare officer, I mean,
It's to me.
I'm thinking that a matter as this, a matter such as this to me seems to be a bit unusual, and I think that it's something that a senior person would really engage a very senior person in the bank. Now, I am aware that banks do make special provisions for persons under certain circumstances, so I'm a little taken aback that a junior officer would have probably made a phone call to the bank and was told that it could not be done. But my question's really tied to the entire procedure under which this service is being made available then to inmates. I mean, are inmates aware that they can request these type of services? Are family members of inmates aware that they can come to the prison and make a request because they cannot access the bank account of their relative that is incarcerated? You indicated that in this particular case, only one adult remandee made that application.
The prison officer in question.
Is there an application form? What is the application procedure that applies? And also, if there is or if isn't, how many requests like this would have been denied over the same period, January 2015 to present, where 9 persons were taken out to conduct personal transactions? Do you have a record of the number of persons who were denied so that we get a sense of how frequently this type of service is required? Since you have indicated that you are trying to ensure that person's life do not stop, just want to get a sense of how many is there in fact some level of favoritism that has taken place in this particular instance, but what is the standard really going forward and how this will apply?
Just to put on record, Mr. Wolcott spoke specifically to banking transactions. We have over 16 transactions ranging from the View Corps as well as ID cards that have taken place from 2015, and these records will be provided to the committee for substantiation.
I'm a little curious what the ID card wants to do. I mean, because I'm wondering, is this such an urgent matter that a prisoner whose ID card has expired, they be allowed to renew their ID card? I'm not sure what use they would have for ID card or a driver's license or a passport while they're incarcerated.
Winding up now, from the questions you have heard from this committee, we representing the Parliament and the Parliament representing the larger society, we were expressing to you some, as we perceive them, of the public concerns around this matter. Those public concerns, in our view, in my view at any rate, having listened, because I had a chance to review it, what Inspector Alexander said on his program, having listened to a lot of the talk radio, because this thing went on for days in the public, and I'm sure you're aware of that. Having listened to all of those public sentiments, I would like to place on record my own, and I am sure my committee would agree, that the reaction of Mr. Alexander and our questions here today reflect genuine public sentiment. And therefore, the labels of reckless and malicious and all of that, I consider to be grossly unfounded, because it was very, very discomforting for these 2 people to run into this man in the bank in the circumstances that we have already described. And as an onlooker, looking at those facts, it was discomforting to me and obviously to the members of this committee. I want you all to understand, Mr. Commissioner and your team, that all of that was an expression of public concern and public sentiment. The public still wants to know, through us, whether you had a written policy on this matter. What's the answer to that question, Mr. Commissioner? On the question of the release or a permission to access personal services of the likes we describe here today outside of the prison wall, do we have a written policy or standard operating procedure on this? Yes or no?
Yes, sir.
Good. Will that be made available to this committee at the earliest opportunity? In fact, we'll send a letter requesting it formally.
Yes, sir.
And we expect your usual prompt and professional response.
By all means necessary.
The other question is, you mentioned, and Mr. Caraspi and I think Mr. Walcott mentioned, this concept of discretion. And based on the deliberations today, we came to the inescapable conclusion that a lot of what is decided is done on the basis of an expression of of the discretion of the decision maker. For an example, Mr. Cecil Duke, when he was acting as commissioner, he exercised a discretion, because if there was a written policy and standard procedure, he would have come to a conclusion that would have been similar to anybody else's, if it was written and there was a standard operating procedure. But you introduced the question of discretion. Mr. Duke, exercising his discretion, decided that Jerome Henry ought not to be allowed out of the prison walls to witness the internment of his son. I am aware that Jerome Henry was brought from the prison to the funeral home on the morning of the event. He was allowed to see the body in the parlor at the back, and he was given one of the funeral programs. In my conversation with the prison commissioner that morning, he said to me, truthfully, that Jerome Henry told the prison service that he did not want to stay to witness the service and incarceration of his son. I want to report that I had personal conversation with him up to last evening. And if I'm misled on the basis of what he said. He said that that was not the truth. What he was told by prison officials on that day is that that particular area, and the funerals in the Piccadilly Street area, from a funeral home on Piccadilly Street, Upper Piccadilly Street, in the area of East Dry River, he said they told him that the reason why they're not going to allow him to stay, and he will only spend a few moments, and it got so bad, they were telling him 5 more minutes, 3 more minutes, 2 more minutes, while he was going through the trauma of losing his son on the one hand and being in police custody on the other. He was being told that that area was risky, and that's the reason why the prison service didn't want to stay around there with him very long. So it appears from that there was serious consideration about the safety of the prison officers, unless in terms of his trauma and his circumstances. I must ask you, Mr. Commissioner, you were not in the chair, I must ask you this question. Having listened to the decision of Mr. Cecil Duke on your return to your lofty office, and having been aware of the policy written, as you told us, exists, on the same facts, would you have come to the same conclusion that he did?
That's a very good question, sir. I take into consideration my mission and what I'm about in touching the lives and saving the lives of all people. And I said before, preparing them for the reintegration, taking into consideration all the risk factors, I would have put the necessary security protocols in place to ensure that all would have been well. I most likely would have allowed him.
Thank you very kindly for your candor.
So, to the funeral, taking into consideration all that I was said before.
From your candor, for your candor, we are in admiration. We are in admiration. But it tells us another thing, that this written policy is the subject of a wide range of discretion, and that is probably the reason why there is so much public concern. And one of the things we would like to see from this committee is a hardening, a better shaping of that policy, so that it doesn't matter whoever is in the chair or whoever has to make the decision, whether it's Mr. Walcott, Mr. Karaspi, or Mr. Pulchan, or Mr. Duke. The procedure and the policy should be so clear, and every prisoner should know it. And the public of this country should know it, so that there won't be any fear or concerns about its uneven application. Because as between Jerome Henry and between this incarcerated citizen who happens to be a prison officer, it has generated a view that the policy is not evenly applied, not applied in a common sense even manner, and as such it has generated this concern in the public. And my final question before I allow my colleagues theirs, I would like to know whether that was the first occasion when that particular inmate was allowed outside of the prison, or whether he was allowed outside for other reasons prior to that. And let me say, these proceedings are on record, in public, and answers are important. Let me say, these proceedings are recorded, they form part of the parliamentary record, and if you don't know the answer, research before you answer. The question is whether that particular inmate was allowed out on that day. Let me tell you the day I'm talking about. It was Friday, the 25th of November, 20.
Yeah, I didn't know.
No, it was reported to the media on that day. What was the day? I'll tell you the exact date.
Give me opportunity because his ID card was expired.
Mr. Walcott, just so that I would not err, what was the date on which this prisoner was taken to the bank? Your records will show. We have the date that it was reported in public. It was November 25th. I am correct. Yes. Are you sure? Friday, November the 25th. Thank you very kindly. The question then is, Mr. Walker, this one is directed at you because the commissioner doesn't know everything, you know. Commissioner doesn't know everything. He has delegated authority under law, and I understand that. I'm asking, the incident that took place, or the event that took place where he was allowed to go to the bank on that day, the question is whether that was the first occasion since his incarceration that he had been allowed out of the institution to conduct a personal matter. That's the question. Are you in a position to answer that now, or you want to research and reply to us?
Yes, I can answer it now.
Please.
It is not the first time.
Could you tell us how many times prior to that that particular inmate was allowed out to transact business of a personal nature?
He was allowed on 2 previous occasions.
On 2 previous occasions. For what purposes?
All were related to the same bank issue. All were related, let me explain, because the bank required for him to set up the account, for him to get his ID card. So from the EBC. And his ID card was expired. We made contacts with the EBC and they furnished the transaction.
Mr. Walcott, I had asked you a question earlier, and I get the impression that that the answer is no, but I just want to be clear. Let me ask you in as open-ended a way as I can. Who in the bank told you that the power of attorney could not be used?
Sir, I did not do that investigation myself. So I cannot tell you, I do not have that information here.
Okay, do you have anything in writing from the bank where they have stated that they would not allow the power of attorney to be used?
We will try to seek to furnish that, right? We will check again to the, excuse me, we will check again to the officer who investigated the issue, and based on his report, we will let you know.
So you, of your own, don't know if there's a letter on this man's file, this prison officer's file from the bank, stating that they would not allow the power of attorney to be used?
At this time, no. I don't have that information in front of me.
Do you have that man's file here with you?
No.
So you came here without his file?
We do not, we try as best as we can to keep the file where the inmate is at. So it is against protocol for...
Okay, but this is a Joint Select Committee on National Security, and you came here without a copy of the file?
I came here with pertinent information related to the file, but I did not copy every single aspect of the file.
I just have one more thing before Senator Coppin and Vice President De Freitas chime in. So, from what you have said, would you not agree that it seems it must appear to right-thinking persons that in this little advent here, the bank security were the ones dictating security matters as opposed to you?
That is incorrect, sir.
But they were the ones telling you when to come and so on?
I will leave that to the operations person, sir.
How are you able to say that they were not the ones dictating the pace in terms of security, in terms of when and where?
If I may, sir?
Yes.
Assistant Commissioner of Prison D. Pulchan. We had our security in place in the bank that work along with the bank security. Right? They didn't dictate our pace for us. We were in command of the prisoner at all times.
But sir, respectfully,
yes, sir.
They were the ones who said no to coming after banking hours, not you. Not so?
The bank has their own protocol, which we have.
I know, but what I'm saying is they were the ones who dictated that he will not be coming into a bank after banking hours, but he must come during banking hours. You didn't make that decision. That was their decision.
And the bank have its rules that we are all obligated to carry out, sir.
But there's national security and there's private bank security. So on this occasion, it seems as though they had the upper hand in terms of security arrangements. You don't agree with that?
No, sir, I don't agree with that.
How so?
We were in control at all times.
Control of what?
We had our officers present. We had the inmate under our confine. We have taken inmates prior to this without handcuff in different circumstances. So it's not the first time we have done that. So there's static security and there's dynamic security. What we had applied there is a principle of dynamic security.
Which is to let a man charged with murder walk in the free world without handcuffs.
To do supervision without alerting or causing any undue attention towards...
Well, lastly, could this transaction, just like when old people can't leave the vehicle and come out, the manager would come out in the vehicle, could this transaction not have taken place in the prison vehicle?
I can't speak to that, sir.
Who dictated where it would take place? Friday month end? Oh, wait a minute. It just occurred to me, this was month end. This transaction took place month end.
Only
Friday 25th. The 25th would be month end. So the bank invariably would be packed with persons, not so?
What month end is speaking about?
Month end is month end, so this is the 25th.
That's all right.
25th?
25th, sir.
But 25th of the month is when the transaction took place?
Yes, sir.
That's not month end?
No, sir. Month end might be.
Let's see whether we can get the date other than that in the month, Senator Coppin.
Just really a closing comment. As it relates, and this question is posed to the Commissioner really, in winding down, short question. Do you believe that the prison service has a duty of care to the population, the banking population, just general population, to guard against harm being committed against them by a prisoner in their custody. Yes
We are
or no?
committed to the safety. We are committed to the safety of Trinidad as citizens of Trinidad and Tobago, and to the reduction of crime through.
And to prevent, what I'm just asking, to prevent harm being committed from a prisoner against a member of the public
At all
while
times.
he's in their custody, yes?
At all times.
And do you believe, finally, that the prisons service breached that duty of care by, one, failing to have their prisoner in handcuffs, two, not cordoning off an area, three, not warning the members of the public that there was a prisoner potentially dangerous in their midst, and finally, not having uniformed guards present? Do you believe there was a breach of duty of care by the prison service of Trinidad and Tobago?
I will answer you this way, sir. If I believe that there were any danger to the public or the citizens of Trinidad, the law-abiding citizens of Trinidad and Tobago, I would not have approved the visit to the bank. I would have denied it at all times. Because first and foremost, I as a commissioner of prison, my responsibility is commitment to the safety and security of all our abiding citizens at all times.
Thank you very much. Senator Member Oliveira.
Just have two final questions. Number one, who chose
Just
the...
bear in mind, folks, that we're going to wrap at just about 5 p.m., so...
Yeah, these will be my final questions. Who chose the date for the transaction? Who chose the particular date that the transaction was done? Was this the advice to the bank, or was that the date that you all agreed?
The date was chosen based on two factors. It is a combination of it's just a two, right? One, when the prison has the requisite staff and available and all security measures are put in place, combined with when the bank is available to do the transaction. So it's a combination. It's not one person or the other.
Okay, and my second question is, at what time did the transaction take place? What time during the day?
It's in the morning period. The AM.
In the morning?
Yes.
Okay, well,
AM.
now you said it was on Friday, November 25th. This would have been the Friday before the general election on Monday. And we are aware that public servants tend to get paid on the 24th. Well, most monthly paid persons get paid on the 24th. I'm just thinking that if you had properly done a risk assessment, you would have recognized that this particular date would have been one in which there would have been a lot of persons in the bank. So I'm just wondering if this wasn't one of the factors that you would have considered in your risk assessment, in number of, because typically there tend to be more persons in the bank towards the end of the month. If I have to do a transaction in the bank, I would choose a Wednesday in the middle of the month.
Thank you. Obviously, they didn't consider that. That's why they chose the 25th. And to hear that it was chosen because they had requisite staff and security and that is not very comforting. I thought you had that 24 hours a day, every day. But Senator Vice President De Freitas.
Yes, I just wanted to ask, because I think this may have come out in the earlies, but was the court anyway involved in this process by way of the judge to whom this case is in front of, because it's an ongoing case? Was that judge made aware of any of this?
No.
No. It was all done on the discretion and policy with stealth of the prison service. Folks.
And just the fact that the inmate is awaiting trial is not before a judge at this time.
All right. Thank you very much. Now, folks, time has run and we have covered ground. We will be sending a letter to you reminding you of the things that you promised us upon review of the notes that we would have recorded today. We urge that you, I'm sure you will, Mr. Commissioner, cause a review and revision of the particular case and the general policy and its publication to be considered. We hope that that is the outcome, and we will report to the larger Parliament accordingly. But before we close, Mr. Commissioner and members, on the 24th of July 2015, a very historic event took place in the life of Trinidad and Tobago and the prison service in particular, when a number of prisoners broke out of the Port of Spain prison of Upper Frederick Street with firearms from inside of your prison. And it led to the death of a particular police officer who was on duty outside of the prison, and general mayhem and trauma to the citizenry of Trinidad and Tobago and the world. I am aware, based on our previous interaction in this committee, and you appeared before us in that regard, that you, Commissioner, under the Public Service Regulations, caused an investigation to be done, and the report of that investigation was made available to you, and in keeping with those regulations, you dispatched the findings to the Public Service Commission. Am I correct?
No, sir.
Could you correct me then, please?
I surely will, sir.
Please, as briefly as you can.
I will be most candid. That report under Regulation 90 was sent directly to the Service Commission from the investigating officer.
Thank you very kindly. So I appreciate that. Thanks for the drawback. And it was sent to the Public Service Commission. Okay?
It was forwarded to
recently, and this was published in the Trinidad and Tobago Guardian on the 5th of December 2016, and it was given wide coverage on the electronic media as well. The Prison Officers Association issued a detailed statement at the hand of Sharon Richards, its president, complaining essentially that 3 of your officers, as a consequence of this matter, had been put on suspension pending disciplinary charges and so on, and that nothing has been forthcoming from the state in relation to this, and that it is adversely affecting the psyche and the well-being of the prison service. And essentially he was calling for a resolution, an outcome to these matters. He calls on the Commissioner of Police to provide the public with a detailed update of the status of the investigation. The statement called on the Minister of National Security to advocate for the matter to be thoroughly investigated so that the truth may be unearthed, among other things. And most of all, he called, or the association called on the Honorable Prime Minister Dr. Keith Rowley, as head of the National Security Council, to place this matter on high priority at the next National Security Council meeting inter alia. I and my committee, in light of this very public outcry from the Prison Service Association, and taking into account that there was no dissociation of the comments made here by the Commissioner of Prisons on behalf of the prison service, took the matter as though it were an expression of the prison service. And in anticipation of your presence today, we asked the clerk to write to the Public Service Commission for a status update on this matter. That came to hand on December the 7th. And I would like to read for your benefit, Mr. Commissioner, and the benefit of all Trinidad and Tobago, the facts as related by the Public Service Commission. Mr. Pulchan, this committee had learned previously that Mr. Dennis Pulchan, now Assistant Commissioner of Prisons, conducted an investigation as was required by the Public Service Regulations. Mr. Pulchan submitted a report to the Service Commission Department on October the 2nd, 2015, more than 1 year ago. The committee, our committee, requested from the Director of Personnel Administration information on what action the Public Service Commission has taken pursuant to the public service regulations to deal with these disciplinary matters against these 3 officers who have been suspended from duty pending these. And from the information we have, let me share with you this timeline. On the 2nd of October 2015, the report was sent to the Public Service Commission, as I stated earlier. On the 16th of August 2016, some 8 months later, the Public Service Commission took the decision to refer the matter to a disciplinary tribunal. On the 30th of August, the Commission considered relevant issues and decided that the proper procedure had been followed. Let me pause. You will recall that this committee raised with you whether the proper procedure was embarked upon. We were assured by you, Commissioner, that it was. It appears as though, and we have information, that in response to a letter from some person, the Commission decided on the 30th of August 2016 that in fact the proper procedure was followed by Mr. Pulchan and by your good self, and the matter is now before them, properly before them. On the 6th of October 2016, the disciplinary tribunal was informed of their appointment. And note that that was 1 year after the investigation report was submitted to the Public Service Commission. On the 13th of October 2016, 1 member of that tribunal resigned as a member. And on the 6th of December 2016, a couple days ago, the Public Service Commission cancelled the appointment of the entire tribunal and informed us that another one is to be appointed. So based on this horrific, in my own view, timeline, it is noteworthy that of as recent as the 6th of December 2016, almost 1 year and a half after this incident, disciplinary proceedings have not even commenced against those officers who are the subject of this investigation. And worse still, the DPA informed us in writing that, and I quote, "Hearings before disciplinary tribunals are currently heard over a number of years, an average of 3 to 5 years." Mr. Commissioner, these are the facts. These are the facts for your own consumption and contemplation. These are the facts for the benefit of the Prison Officers Association. These are the facts for the benefit of the government of Trinidad and Tobago. These are the facts for the citizens of Trinidad and Tobago. So when the Prison Association calls on the Honorable Prime Minister and the Minister of National Security and the Commissioner of Police, these are the facts. I thank you very much. Mr. Commissioner, we on this committee would like to thank you yet again for your presence before us. We commend you again for your perspicacity, your professionalism, your prompt response to all the inquiries we submit, whether in writing or viva voce as of today. We commend you as well on your candor, your frank approaches to dealing with things in a world of secrecy unnecessarily very often. We would like to thank you and your officers for coming. You have shed light on the matter that we had an inquiry over today. I leave this table, and I think I speak on behalf of the committee, not altogether satisfied that we have a firm policy and an evenly distributed or manifested practice in relation to prisoners being allowed outside of your walls. We urge you, on the basis of the deliberations today, to look again, think again, and to see whether you have a sound policy, standard operating procedures clearly defined, such that any one of your officers delegated to make a decision would be so guided. We ask you to think again, because this has created serious discomfort in the minds and hearts of the citizenry of the country, which we reflected here today, and which, in fairness to him, Inspector Alexander, and beyond the tape, expressed. And as I said frankly, I did not consider their intervention to be reckless or anything else, but an expression of genuine public sentiment. So we thank you very much for coming, and we permit you to say a few comments as we close, in fairness to you and the organization. Thank you.
Thank you kindly, sir. I appreciate. Let me say this, that the committee has already been formed to look into the policies, have a written policies that will conduct the affairs of all inmates, both convicted and unconvicted, leaving our institution. We have revisited, and we are now doing the necessary amendment to treat with all aspects of inmates leaving our institution. In addition to this, as we seek to prepare all persons within our care to touch and save their lives, to prepare them for their reintegration, we allow certain inmates to leave our institution who will have certain skill set, taking into consideration the risk assessment. We keep that connection with the contact with the family on the outside. Because, as you will know, rightfully know, sir, we have a number of inmates within our unconvicted inmates that have been in our environment for far too long. And we, by all means necessary, have to find a way. Because as I asked the question before, is prison to use as punishment and for punishment? We find our way, taking consideration the risk to our citizenry, to allow them to participate, to assist, because we believe in prevention. Prevention is better than cure. And that's why we have the different programs geared towards, like, for example, as I said, the mentoring program, and a number of programs. Just recently, as you will know, we will have carried 100 and odd inmates to the cathedral, all part of their rehabilitation, to give them that motivation and an incentive to change the way they think. Because we know that if we're talking about change and transformation, and we're talking about public safety, we have to be talking about the remuneration of the mind and how we treat inmates in a professional and human manner. And our drive continues to do towards that. I am saying here now that while I'm commissioner, inmates both convicted and convicted, unless I am stopped, will be allowed to go outside as long as the risk deem. Let me say that, I call it good risk, to help in their development and empowerment. Because I am of the belief that they, one day, will be in our neighborhood, in our communities. And I have to do all within our powers, with the opportunity that I have under supervised and controlled environment, both internally and externally, to prepare them as productive, law-abiding citizens of Trinidad and Tobago. We need everyone's help.
Thank you.
We need everyone's help. We know crime is everyone's business, and we continue to do our best within our capacity. I do appreciate it. Thank you.
Thank you very, very much, Mr. Commissioner, and your team, and give you an assurance that in keeping with the work of this committee, at some stage, and I hope the not too distant future, we will engage you yet again to have a closer look at this policy, which I know In 2002, the Cabinet of Trinidad and Tobago accepted as policy where we redesigned penal policy from retributive to restorative. So it is now government policy. We accept that, and at some stage in the near future, we'll give you an opportunity to tell us a little more fluently what these things engage and involve. I thank you very kindly. Thank you very much.
Thank you. Thank you,
This
sir.
committee
On behalf
meeting,
of
this
all of us.
public hearing is now at an end. Thank you. Members, we have still. Thank you.